This video is for California Realtors. My name is Amanda Rocha. I am an estate planning and probate attorney in California, and today I'm going to give you 10 things you need to know about trusts. Before I get into that, I want to give you my contact information so you can ask any questions. You can find me on my website at www.amandarocalaw.com. You can comment down below if you have any questions or you want to have me make another video. Follow along on social media at Amanda Rocha Law, and you can send me a direct message there. So let's just get into this. Number one thing you need to know about a trust is that trust can hold title to real property, which means, number two, a trust can avoid probate. So if you have your clients purchasing real property, you should advise them to get a trust in order to avoid probate, because a trust will take the title out of that person's name and put it into the trust name so that when that person passes away, they don't technically have that real property that would trigger the amount for probate. Number three is a trust is you can only have a joint trust with a married couple. It's only for one person if you're not married. And if you are married, you can have separate trusts, but you can't have, let's say, a mother and child who own a home together have a joint trust. It doesn't work like that. They would need to have their own trusts. Number four, you can transfer title to your trust after you purchase your home. You don't need to have your clients rush and try and get a trust during the closing process or after they've contacted you or before they find a house. This can happen afterward. It doesn't need to be something you have before taking title to a house. Number five, don't quote prices to your clients about what you think a trust is going to cost. I would say less than $5,000 for most people, maybe. I've seen other realtors say things like, it's only going to cost you $1,000, which isn't necessarily true. The cost of a trust really depends not only on what kind of trust you need, and there are about 28, 27 kinds of trusts, but also where you are in the state, what other property you own, whether it's joint or single, whether they're going to have additional estate planning products, whether that attorney does flat fee arrangements or hourly. There's just too many variables to give somebody a price, especially if you're going to give them something so low that they're afraid when they actually talk to an attorney at what it should cost. Next, mobile homes and modular homes are treated completely differently when it comes to probate and when it comes to what to do with the trust. That doesn't mean a trust can't own them or have title to them. It just means that if you are selling these kinds of homes, know that there are special rules and know that the traditional probate process might be different for them. 7, not all trusts are created equally. As I mentioned, there are close to 30 types of different trusts. Some trusts actually will take a title to that property, and the person who owned the property before transferring it to a trust no longer has the ability to do anything. They lose basically ownership rights and they can't do anything with that. Which brings me to number 8, living trusts. Revocable living trusts are the kind of trusts where somebody can own a home, transfer title into their trust. They are the trustees, and then they still have the ability to sell that house or rent it out or buy a new house and add it to the trust or add as many houses as they want. It's revocable, and they can change it as many times as they want during their lifetime. Irrevocable trusts are a totally different game, and that is why you should, number 9, never have anybody download a trust online to try and use, because you just don't know what kind of trust you're getting. And even if you do think you know what kind of trust you're getting, it might not have all of the clauses and things that you need. You could be taking away rights from yourself as the owner, or giving people rights that you don't think that you're giving them. So that's a no-no. Number 10, capital gains is not something that is added or calculated when you are inheriting a property. it is something that somebody has to worry about if they're adding a person to title after the original purchase date. So make sure your clients know that they will avoid capital gains by passing their property along through a trust to their children as opposed to adding their adult children to their title during their lifetime. That can be a big cluster. So if you have any questions about trusts, please feel free to reach out to me. You can find me on my website, www.amandarocalaw.com. Comment down below if you want me to respond that way, or slide into my DMs by following me on social media at Amanda Rocha Law. Thank you.